seated. We'll hear argument in 21-165, in re Whataburger Restaurants.
May it please the court, Mr. Wright will present argument for the relator. The relator has reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice. May it please the court. This mandamus proceeding concerns the enforcement of an arbitration agreement in a non-subscriber workplace injury case. This case has a long history in the trial and appellate courts, including this court. The first time the motion to compel arbitration was submitted to the trial court was in 2013. The judge of the county court in El Paso denied that motion to compel arbitration, and at that time, Whataburger pursued an interlocutory appeal under Section 51.016 to the El Paso Court of Appeals. That court reversed the trial court, and in the course of its ruling did not dispose of all issues necessary in the appeal. This court, on petition for review, granted the petition and issued a per curiam opinion directing the case back to the El Paso Court of Appeals so it could dispose of all the necessary issues in the case. The second opinion of the El Paso Court of Appeals issued in 2017, and that opinion is significant because it narrowed the issues that would be before the trial court the second time. And the second opinion of the El Paso Court found that a valid arbitration agreement existed, that there was mutual consideration for the reciprocal promises to arbitrate, that the arbitration agreement covered Ms. Cardwell's claims in the lawsuit, and that the arbitration agreement was neither substantively nor procedurally unconscionable. So the only issue remaining after the El Paso Court of Appeals 2017 opinion was whether the arbitration agreement is illusory. And the El Paso court ruled that the case needed to be remanded to the trial court so the complete employee handbook from Whataburger could be submitted into the record. The initial submission did not contain the complete handbook. So Whataburger then filed what it styled a supplemental motion to compel arbitration in 2018. That motion came before the court, and Whataburger addressed in detail the illusory contract issue. The trial court's ruling is now the subject of this proceeding. We now know that the trial court issued an order denying the supplemental motion to compel arbitration on August 23rd, 2018. The legal issue that's before this court was caused by the fact that the clerk of the court did not give notice or serve the parties, either Whataburger or Ms. Cardwell, with the order, and it was not known to Whataburger until more than 90 days after the order had been signed. It came to Whataburger's attention on January 23rd of 2019. Whataburger learned on that day also that Ms. Cardwell's counsel informed Whataburger that they had not been served with the order either. So Whataburger immediately commenced a proceeding in the trial court before a successor trial judge, respondent Judge Morales. Within 8 days after learning of that order, Whataburger filed a motion to reconsider and also a Rule 306A motion to establish the date upon which it knew or acquired knowledge of the order. Judge Morales denied the motion to reconsider. His ruling on the 306A motion was that Whataburger did not know or acquire knowledge, did not have notice or acquire knowledge of the order within 90 days after the order was signed. And the effect of that, of course, was that Whataburger's right to an interlocutory appeal of the second ruling was lost. And of course, as the court is aware, a motion for reconsideration of an order denying a motion to compel arbitration is not appealable under 51.016. So that left the only remedy for Whataburger to be a mandamus proceeding.
So if you bring a mandamus, and I agree with you, that's clearly a remedy. Why do we need to reach the substantive arbitration questions? Wasn't the deprivation of your right, the right to be given adequate notice of a ruling and to not have your right to an interlocutory appeal eliminated by action of the judicial branch of the government?
We believe it was, Your Honor.
So shouldn't we then say the mandamus relief is to, direct the lower courts to give you a proper judgment, to set all of that aside, and the judge can go and issue his order again if he wants to, give you proper notice under the rules, and then you can pursue your interlocutory appeal in the proper course?
Well, that would be one remedy. We believe, though, Your Honors, because the question of whether a contract is illusory or not is a question of law.
That's true, but if we reach that question of law, do we not then set the precedent where anytime a court purposefully or negligently violates a party's substantial rights through the unjustified delay like that we would now be saying, okay, the proper thing to do is to bypass the appellate process and now bring the questions that would have been appealed, have them addressed on the merit through the mandamus standards instead of, and they won't always be so easily resolved, without prejudging anything, but you've brought us a question of law. Why wouldn't we instead be better serving the jurisprudence of the state by saying very clearly, the court does this, that's terrible, you're mandamus, and now we're going to get you back on the right track, and not to start resolving the merits through mandamus itself?
Well, I'd certainly agree that would be the simplest ruling, but I would remind the court that the successor judge himself has already seen the merits of this in the motion to reconsider, and he's already denied it. But
the Court of Appeals hasn't ruled on the underlying legal issue regarding whether it's illusory or not, based on the complete record with the handbook, right?
They did not address that. Justice Alley's dissent addressed all of that, but the Court of Appeals did not address the merits of the illusory contract issue.
So what do our, following up on Justice Young's question, what do our cases say about what the proper remedy is if the thing that you're mandamusing about is a procedural problem in the trial court? Should we correct that procedural problem, or should we then go on to rule on the merits of whatever the trial court was ruling on when it messed up the procedure?
Well, I would say in the abstract, it would make sense to remand perhaps to the Court of Appeals to address that issue. But I think it's the reason I'm hanging up is just that the history of this case is so long and twisted.
But we have to write a rule for more than just this case.
Yes,
so
I'm sorry.
That's why I'm asking what our other cases have done in similar circumstances. Do we have cases where there's a procedural problem that we're trying to fix on mandamus, and instead of just directing the trial court to fix it, we go on and rule on the merits ourselves?
Well, I can't call a case to mind immediately, but my strong sense is that the court has addressed the merits when a question of law like this is presented.
Have we had cases where, because of other kinds of procedural defects, we have treated, in the arbitration context, a mandamus like an interlocutory appeal and vice versa? Because, there was that window where it was really difficult to tell what the proper appellate vehicle was. So in an instance where the delay in getting notice of the trial court's order makes no difference, then there's nothing to correct. If the delay results in the absence of an appellate remedy that you otherwise would have, wouldn't the way to correct that be to address the merits of the appeal?
I believe so. And I think the mandamus case law would support that. Of course, before 51.016 was enacted, mandamus was the only remedy that was available. So a lot of the cases that the court addressed were almost all on the merits, because the notion was that the motion to the motion to compel arbitration had been denied, and the court took it upon itself to address the merits of that. I don't think I've made myself very clear of that, but I agree with what you're saying. I think there are a number of cases where the court did address the merits, and I think we've cited a number of the older cases in our brief that addressed the issue of the appropriateness of mandamus and the reasons for it, to preserve that remedy, to obtain the benefits of the contractual arbitration agreement, and to avoid a waste of judicial resources. I think it would be more efficient for this court to address the pure question of law, because it's a gatekeeper issue. It's never going to be an issue that goes to a jury. This court has the complete record. We believe it would be more efficient for this court to address it at this time.
Weren't those cases decided before the legislature made the statute apply to all sorts of arbitrations to where you could have an interlocutory appeal rather than a mandamus?
Yes.
And shouldn't that make a difference if you're looking at mandamus, where one of the questions is, do you have an adequate remedy by appeal? And I understand that you're saying why you're saying you don't have an adequate remedy by appeal in this particular case, because you didn't get notice. But it seems like in fashioning a remedy for that, we should be cognizant, because we have to look at whether there's an adequate remedy by appeal generally in mandamus. Shouldn't the remedy that we fashion be consistent with any appellate remedies that exist?
Yes, I do. Yes, I do agree with that. But I'm also, I'm sorry to keep coming back to this, but I'm also just looking at the record in this case and how long this has taken us to get to this point. If you send it back to the El Paso court, that will be their third. They'll be writing, actually their fourth opinion in this case. 2 on the merits and 1 very short mandamus opinion. And we believe this court is well situated to deal with the merits, especially on a question of law like this, with the record fully developed.
I think you had a merits point you were going to, and it's not my fault, I derailed you, but please make your merits argument.
Thank you, Your Honor, I will. The merits point is that the arbitration policy is not illusory. And there are essentially two primary reasons for that, and these are founded in well-established cases of this court. The first question is whether Whataburger had a right to unilaterally refuse to arbitrate once the facts giving rise to a covered claim arose. And this has been addressed by the court. 3 decisions in particular come to mind. One is the 24R decision, the Halliburton decision, and the Odyssey Healthcare decision. And if you look at the arbitration provision, in this case, it specifically states that Whataburger may not terminate or modify the arbitration remedy after facts giving rise to a claim have arisen. And it goes beyond that. It has a 30-day notice provision, which in fact is broader than the provision in either Odyssey Healthcare or Halliburton. I believe they both had savings clauses. So for that reason, the arbitration policy is not illusory. The second reason is that the arbitration policy, even though it's physically located within the employment handbook, is a standalone agreement, and it does not incorporate the remainder of the employee handbook or the acknowledgement sheet that Ms. Cardwell signed when she became an employee. I expect you'll hear argument from Ms. Cardwell's counsel about the acknowledgement sheet and what is and what is not covered by certain paragraphs of that, and I won't belabor that at this point, but I will say, and the handouts that we provided to the court have what we believe are the most relevant provisions on this point, and they very clearly carve out the arbitration agreement as a separate contract, and they limit Whataburger's right to amend or modify the agreement. So for those 2 reasons, we believe that the arbitration policy is not illusory. And I would also mention, Your Honors, very briefly, Justice Alley's dissent addressed rules of contract construction and how those play into this in terms of addressing the argument that Ms. Cardwell made in the Court of Appeals. And Justice Alley said that there were 3 rules of construction that were violated by Ms. Cardwell's argument. The writing must give effect to all provisions so that none are rendered meaningless. No single phrase or sentence should be isolated from its setting and considered apart from the other provisions. And I think in this case, very importantly, specific contract provisions must control over general ones. And I think if those principles are properly applied, as a matter of law, the arbitration contract is not illusory and should be enforced.
Any other questions? Thank you, Mr. Wright. We'll hear from the real party.
May it please the court, Mr. Pownell will present argument for the real party in interest.
May it please the court. Good morning, Jeff Pownell on behalf of Yvonne Cardwell. I hope to convey three themes in my argument this morning. The first is on the issue of whether Cardwell established a valid and enforceable arbitration agreement as a matter of law, which is just a different way of saying whether the trial court abused its discretion in denying the motion to reconsider, because the only way the trial court could have abused its discretion is if Whataburger established a valid and enforceable agreement, arbitration agreement as a matter of law. So on that issue, the first theme I hope to convey is that when it comes to principles of Texas contract law, language matters. It's supposed to matter. The second theme I hope to convey is on the issue of whether Whataburger had an adequate legal remedy. The theme I hope to convey is that the rules matter, or at least they should. And finally, on the final issue of whether there were some other equitable grounds that would warrant mandamus relief for Whataburger, conduct matters, or at least it should. So with that in mind, I'm working a little bit differently. I'm going to start with the merits issue, because I do think that is a little bit more complicated, and there's at least one or 2 points that I want to make sure I get that the court hears. And on the other hand, I think the last two issues, the court may be more interested, the court may send me a different way, but I do think that the last two issues, whether there's an adequate remedy, which is kind of two subparts to one issue, whether there's an adequate remedy at law, or whether there was an adequate remedy at law for Whataburger, and whether there was some reason to justify mandamus relief. I do think those issues are a little bit more clear. So with that in mind, let's start with the issue on the merits as to whether Whataburger established a valid and enforceable arbitration agreement in front of the trial court as a matter of law. And counsel for Whataburger is correct. I am going to talk about the acknowledgement sheet. That helps us, I think. And but I want to begin. Often, I think the complicated part of an appeal is really deciding what the issue is. Sometimes once you figure out what the issue actually is, then the rest of it kind of solves itself. And I think that this is one of those cases where there is a disagreement over what the issue is. And I think the issue is what really constitutes the agreement between the parties. And how does the acknowledgement sheet fit into the Texas arbitration policy? And so the reason why I say that is because I believe, and for the reasons I'll talk about, that the only way Whataburger can establish that the Texas arbitration policy is standalone is if we just pretend that the acknowledgement sheet doesn't exist. And because the acknowledgement sheet helps us in two ways. It not only helps us with the first language, the first part of the language that says, I understand that the information provided in the employee handbook is intended to be used as a guide only. Its provisions are not conditions of employment and may be modified, revoked, changed, or deleted by Whataburger at any time with or without notice. So we have an illusory provision in the acknowledgement sheet. There's a non-illusory provision in the arbitration policy. And we don't dispute that. So the real issue, we believe, is how do you reconcile the non-illusory provision in the arbitration policy with the illusory provision that's in the acknowledgement sheet. And we believe that the only way to reconcile that is to interpret two words in this paragraph. The first is the word provision, and the second is the word manual, because it says the information provided in the employee handbook is intended to be used as a guide only. Its provisions may be modified, revoked, changed, or deleted by Whataburger at any time with or without notice. Then in the next, and then there's one more sentence, and then the last sentence of that paragraph, nothing in this manual is intended to create, nor is it to be construed to constitute a contract between Whataburger and any of its employees. So Whataburger's argument is, well, this doesn't really matter because it's not part of the agreement. But
Was there a separate initials somewhere? Did your client initial the arbitration policy somewhere? And in the context of what you're describing, how does that fit in?
Client did not initial anything regarding the only thing the client initialed or signed is in the acknowledgement sheet. So, and there is a separate provision that I was going to come to that's titled arbitration that is initialed. And that may be what Your Honor is referring
Yes,
to.
but that wasn't your client. That was someone, the employer or someone else?
No. That was our
Your
client.
Okay.
Yeah. But keep in mind, the arbitration policy, well, I mean, obviously we believe our argument is the arbitration policy is in the employee handbook, right? But what she initialed is the paragraph referring to arbitration that's in the acknowledgement sheet, which in my mind is even, I think we have to separate the issues here but we have to first decide what constitutes the agreement between the parties. Or probably a more precise way to describe it is, did this acknowledgement sheet modify a previous, even if we assume that the arbitration policy that's contained in the employee handbook was, by itself non-illusory.
You do assume that, right?
I'll be happy to, yes, Your Honor, I'll be happy to assume that. But the reason why the acknowledgement sheet has to be part of it is because without it, where's the unequivocal notice? Because Ms. Cardwell didn't sign anything actually in the employee handbook.
She initialed the arbitration paragraph in the acknowledgement sheet, which seems to stand alone.
That's exactly right, but in the acknowledgement sheet. But what that means, or at least that's what we believe means, is that is very strong evidence that the acknowledgement sheet is part of the parties' agreement. And I want to make that, I think that's a very important point, because Whataburger's position is that the acknowledgement sheet is not part of the parties' agreement.
But if the description of the employee handbook in the acknowledgement sheet, as you're arguing, sort of reaches back into the handbook and renders the otherwise enforceable arbitration language in the handbook illusory, why doesn't the very next paragraph that's separately initialed create a distinct arbitration agreement irrespective of what's in the handbook?
Okay, I'll go straight to that, Your Honor. I think that's that's an important issue. Let's read that. Well, let's read what it says. Arbitration. I understand that Whataburger Restaurants will submit any legally recognized claim or dispute related to employment, termination of employment, including workplace injury or disease claims, except as specifically excluded in paragraph 302 of the arbitration policy to arbitration. 302 is not the non-illusory provision. That's just a provision that that lists some exclusions. But so I stopped there because it's the last part that really matters. The last part is, and by accepting or continuing employment, I shall be required to submit any legally recognized claims or disputes to arbitration. That's why, Your Honors, language matters, because they did not tie it to mutual promises in the arbitration agreement, in the Texas arbitration policy. And that's what would be supported by consideration.
But doesn't, doesn't the arbitration provision you just read have mutual promises? Because the first part says, I understand Whataburger will submit, and then the second part says, by accepting or continuing employment, I will submit.
That is not a mutual promise, Your Honor. And that goes back to N. Ray Halliburton. You cannot use continued employment in an at-will employment relationship to support consideration. That is, in fact, I brought...
The mutuality is that we're both going to arbitration. We both waive court.
That's right. But there are no mutual promises in the acknowledgement sheet.
But it says, Whataburger will submit to arbitration, and I shall be required to submit to arbitration.
That's not what it says, Your Honor. It says Whataburger will submit any legally recognized claim or dispute related to employment, blah, 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 to arbitration, and by accepting or continuing employment, I shall be required to submit any legally recognized claims or disputes to arbitration. So let's use the hypothetical. What if this instead said, and by mutually promising, by virtue of our mutual promises as set forth in the arbitration policy, I'm also required to go to arbitration. If it said that, we'd be in a lot of trouble, because mutual promises to arbitrate will support.
But this,
What if it said, and in consideration for Whataburger's agreement to submit any legally recognized claim to arbitration, I will do that. In other words, he took out all that language about accepting or continuing employment and replaced it with in consideration for Whataburger's promise.
No, I'm sorry, Your Honor. That is the classic example of an illusory contract, because you're not giving them anything in return. There's got to be a mutual promise.
But what I'm trying to say is that so what this provision that she initialed says is that Whataburger shall submit to arbitration, and by accepting or continuing employment, I'll submit to arbitration. If instead of saying, and by accepting or continuing employment, it said, and in consideration for Whataburger submitting everything to arbitration, I too will submit everything to arbitration. Wouldn't that be mutual?
Oh, I see what you're saying. Okay. I think if I understand what you're saying now, Your Honor, you're basically making it a little fancier than it usually is, but you're saying there would be mutual promises. Right. You're saying Whataburger says we promise to go to arbitration if we have any claims, and in consideration for that, Ms. Cardwell says we promise to go to arbitration if
mutual.
That is the classic non-illusory. So
my next question is, what if there was no language in the middle at all? First sentence, Whataburger will submit to arbitration, period. Second sentence, employee will submit all claims to arbitration, period. It doesn't say in exchange for employment or as consideration for Whataburger. It says they both will do so. Wouldn't that also be a mutual promise?
I don't think so, Your Honor. And the reason why I say that is because now you have to go back to the paragraph above. You can't forget what it says with the employee handbook, because it says, in fact, that's the way Whataburger is trying to save themselves from the language in the employee handbook, in the paragraph that's titled employee handbook, is by saying, oh, but look, we've got this carve out because we've got this special arbitration paragraph. So that carves us out. There's only one reasonable interpretation from that. And keep in mind, we only have to show that there's more than one reasonable interpretation. Because if there's an ambiguity, the trial court has resolved that in favor of Ms. Cardwell. So Whataburger's argument can only be there's only one way to interpret this acknowledgement sheet, or there's only one way to travel to an enforceable arbitration agreement, is that we have a standalone agreement in the arbitration policy, and you don't use the acknowledgement sheet. But then you have a problem with unequivocal notice, right? Because that's the only thing she signed is the acknowledgement sheet. So you got to have the acknowledgement sheet to have unequivocal notice, because otherwise there's no evidence at all that Ms. Cardwell accepted anything that's in the arbitration policy. So that's why I would suggest, and I'm glad I started with this, because I see I'm down to 5 minutes. So I'm going to try to wrap this up in the next minute or two to at least have a few minutes for the adequate remedy issue. But be that as it may, I think that's a very critical component. There is no escaping. Whataburger cannot escape the fact that the acknowledgement sheet, at least at a minimum, it's ambiguous as to whether it's part of the agreement. And then once you get there, then it's a relatively straightforward issue, which is, how do you interpret the word provision and how do you interpret the word manual in the employee handbook? And does that, and then, is the arbitration policy a provision in the employee handbook? And is the arbitration policy part of the manual? Because it says nothing in this manual is intended to create, nor is it to be construed to constitute a contract between Whataburger and any of its employees. So that's why now we're left with that issue. Is there an ambiguity there? What does provision mean? And that part is discussed in the brief. But as we said, there's one argument that helps them. So I'm still got to have a minute left before I need to move on. But the argument that helps them in this acknowledgement sheet is at the very top. It is listed differently. It says, I've been provided with copies of Whataburger Restaurants LLC, and then it says Employee Handbook, Arbitration Policy, and EQPP, right? That's what helps them. But actually what hurts them, and I can't emphasize this to the court enough, what I believe hurts them is the actual provision on arbitration, because it doesn't reference mutual promises in the arbitration policy. What it references is it says, we're going to agree to go to arbitration and consider, and you're going to have to go as long as you continue your employment. And we know from Halliburton, it's a 2002 case. It's been here since I was first started having to fight these battles. But we know from N. Ray Halliburton that, a continued employment can be evidence of acceptance of unequivocal notice. If you get unequivocal notice and then you continue to work, that can be acceptance. But in an at-will employment relationship, continued employment cannot serve as consideration. So I believe that helps us. Like I said, if they intended for the arbitration policy to be a standalone agreement, what that paragraph should have said was just as was mentioned earlier, is, and in consideration with your mutual promises to arbitrate as set forth in the arbitration policy. It would have referenced the Texas arbitration policy. It doesn't do that. It says it doesn't do that for Cardwell. It does it for Whataburger, but for Cardwell, it doesn't say you're going to have to arbitrate because of the mutual promises contained in the arbitration policy. It says instead you're going to have to arbitrate because of your accepted or continued employment. Okay, now I'm down to 2 minutes. So that's with that in mind. That's why we believe all we've got to do is get an ambiguity. Is that paragraph reasonably susceptible to? Is somebody going to read this paragraph and say nothing means nothing? If it's in the manual, if it's a provision in the employee handbook, it's not a contract. And then it's in the brief, but of course, even the arbitration policy is listed at the top on every page, employee handbook. In the table of contents of the employee handbook, it says arbitration policy. And there are other provisions that have carve-outs where employee handbook is not listed at the top of the page. So we believe that creates an ambiguity. Okay, Now I've got 1 minute left for the last issue.
Why is appeal after a merits trial adequate if the reason you didn't get an interlocutory appeal was you didn't get the order?
Because the rule, that's only half the rule. 306A also provides for when a party doesn't get notice, regardless of the reason. And you have 90 days, plus the 20 days. Justice Alley gave him 119 days in his dissent, which I kind of got a chuckle out of, because I guess he feels like you need 1 day to put a notice of appeal together. And I can tell you, there's been many times where I've had like 4 hours to put a notice of appeal together. But be that as it may, whether it's 119 days or 120 days, the rule, provides for that. And you've got to show, we believe, we understand mandamus remedy is fact intensive, but you can't just show that you didn't get notice. Because otherwise, what if you didn't get notice for 5 years? You're going to be entitled to mandamus. You're going to be entitled to mandamus. There's got to be notice plus.
If a court of our state signs an order and puts it in the desk for 5 years, you think, well, just too bad?
No. I'm saying the opposite. Well, I'm saying the argument that Whataburger is making is that we could file an appeal. If we didn't get notice for 5 years or something, if we didn't do anything to find out about the notice, to find out about the lack of notice for 5 years, under Whataburger's view of the world, they're still going to be entitled to mandamus relief. So we believe you got to show something. Once you get outside the 110 days, that's what the whole purpose of 306A, the last 306A 4 and 5 are for. Once you get outside the 110 days, you got to show something more. You got to show why or what you did to try to avoid not receiving notice.
Any other questions? Thank you, Mr. Pownell.
Thank you, Your Honor.
Mr. Wright, you have 5 minutes.
Thank you, Your Honor. I want to first start with an evidentiary question. My head is spinning a little bit about the issue with the acknowledgement sheet, but that's not the only evidence. And I think there's an important item of evidence that it's worth your consideration, and that is an exemplar paycheck that has specific language that's on each Whataburger employee's paycheck, and that's found at page 63 of the mandamus record. And let me just read this to you. It's fairly brief language. Whataburger will submit to arbitration any legally recognized claim or dispute related to employment, including termination of employment and workplace injury or disease claims, except as specifically excluded in paragraph 3.02 of the Whataburger arbitration policy. By accepting or continuing employment, Whataburger employees agree to submit the same claims to arbitration. Each Whataburger employee has been provided a copy of the arbitration policy, and additional copies may be obtained from the Home Office Human Resource Department at phone number. So that language is on every paycheck. That
has the same language that your friend on the other side was saying, by accepting or continuing employment is not consideration under Halliburton. What's your response to that?
Well, as I read it, this language was they agreed to submit the claims to arbitration. And the consideration listed is by accepting or continuing employment, which Halliburton says is not consideration. Okay, well, I think we just have a disagreement with him, but
So does that mean it's ambiguous?
No, I don't think it's ambiguous. I think when proper rules of construction are applied, again, that the acknowledgement sheet, plainly, it's a different document than the employee handbook. Our position, as we've briefed it, is that it's parole evidence, especially if it's trying to modify the arbitration policy.
But is this is the sheet the only place she signed anything relating to arbitration? Ms. Cardwell?
As far as I know, except endorsing every paycheck that has this language on it.
But the language on the paycheck is the same as the language on the sheet, pretty much.
Well, if
as you just read it.
Yes, but I'm saying there's other evidence other than the acknowledgement sheet and the employee handbook. I just don't think the acknowledgement sheet gets them there. I don't think as a matter of law it's a part of the employee handbook.
To address the idea that there ought to be some element of diligence incorporated into seeking mandamus relief after the time for filing the interlocutory appeal has expired, whether or not it's due to a lack of notice on the part of the clerk's office.
Certainly, Your Honor, thank you. That's an important element of the mandamus jurisprudence, and that is the party seeking mandamus relief must show diligence and explain their delay. So it's a fact-specific inquiry, and in this case, Whataburger went to the successor court, got a finding under Rule 306A, immediately sought mandamus relief, immediately filed, the motion to reconsider, and following on with that, the mandamus petition to the El Paso court and then this court. So we've briefed that at some length in our briefing, and I think the answer is that the case law imposes a diligence standard and requires an explanation for delay, and we believe that we met that.
So if the order didn't get served on you, but it was noted on the docket sheet, and 5 years had passed, and you could still get mandamus relief at that point without having to explain why you didn't look at the docket sheet for 5 years?
No, I think you have to always have to give an explanation and show diligence in order to be entitled to the extraordinary relief of mandamus. I think that's included within the extraordinary circumstances requirement that would apply. I wanted to address one other point. I believe, if I heard counsel correctly, there was a statement that the employee would not have the right to arbitration if their employment were terminated. That's at odds with the specific language of paragraph 2.01 at page 225 of the mandamus record. That paragraph says the duty imposed on both the company and on employees to arbitrate all legally recognized claims or disputes arising from the employment relationship shall continue beyond and not be affected by the termination of an employee's employment. So I think the statement was just simply incorrect. I think the plain language of the arbitration agreement is to the contrary. And quickly, Your Honors, I wanted to address the question of remedy. And in our brief, we cited a couple of cases about mandamus review may be essential to preserve important substantive and procedural rights from impairment or loss. I think that's really what we're looking at here. We cited the In re Reese case, which quoted In re Prudential for that proposition. Both of those cases also held that mandamus is a remedy not restricted by rigid rules that are necessarily inconsistent with the flexibility that is the remedy's principal virtue. And we believe that flexibility would permit this court to determine the merits of the illusory contract issue as part of the gatekeeper role and decide that question of law.
Any other questions? Thank you, Mr. Wright. The case is submitted, and that concludes the argument set for this morning. Marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.